Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Blazer, Mr. Scheck, Mr. Neufeld, people represented by Ms. Clark, and Mr. Dart. The jury is not present. Record should reflect that this morning the court held 2 in-chambers meetings with counsel, specifically with regard to an issue that has been raised by the so-called Furman tapes. And the record should reflect that although the tapes have been discussed with the court does not have a copy of the tapes, nor has the court reviewed the transcripts that are said to exist with regard to these tapes. Further, during the course of our discussions, counsel for both the prosecution and the defense have advised the court that their review of these tapes indicate that Mr. Furman apparently has made comments that are disparaging of this court's spouse, Captain Margaret York of the Los Angeles Police Department. It's further been indicated to the court that there is a possibility that the prosecution will call Captain York to testify as a witness in this matter in light of that development with regard to the credibility of Mr. Furman. Code of Civil Procedure Section 170.1 sub A sub 1 states as follows: a judge shall be, which is mandatory, shall be disqualified if the judge has personal knowledge of disputed evidentiary facts concerning the proceeding. A judge shall be deemed to have personal knowledge within the meaning of this paragraph if the judge or the spouse of the judge is to the judge's knowledge likely to be a material witness in the proceeding. So at this point, what is necessary to determine is whether or not Captain York will be a material witness in this case, if her testimony would be relevant or material to any of the issues before the court. If that is true, then this court would be required to recuse itself from further participation in this case. All right, I'll hear from the parties. Just when you thought we couldn't have anything crazier happen.
Yes, Your Honor. This has been a most unique case in many particulars. However, Your Honor, the defense rises at this point to indicate to the court we feel this is a tempest in a teapot. Let me make very clear the defense position about these tapes, and then our position, and Mr. Simpson's position, about what should happen as to whether this matter should be sent out at all. First of all, the court is aware that the defense is the one who pursued these tapes, not the prosecution. And I think that's the first point, Your Honor. From a standpoint, this was their witness. They had an obligation to come and tell us about this witness who commits perjury and engages in 10 years of tapes over a period of time, where he's speaking in dialogue, and not only in dialogue, these are interviews with Mark Furman. We're the ones, with your help, who pursued these tapes. And to put them in perspective, what we suggest to the court is this is a ploy by the prosecution, because they don't want to proceed further. We will never agree to a mistrial in this case. This case should not be sent out. What we propose to do is to give you the tapes, which are the province of our work, submit the tapes to you with the portions regarding Captain York redacted. Those portions where Mark Furman, who doesn't seem to like anyone in those tapes, is disparaging, have nothing to do with this case. You have ruled back in January that we are entitled to impeach this man based upon his racial animus, based upon his proclivity or propensity to implicate innocent individuals, and then perhaps a third category of general credibility where he's just lied about certain things. For instance, the fact of whether or not he was going to sue Robert Shapiro. Now, we've heard all of these tapes. These tapes, so I want to make the record very clear. This man is an important part of the prosecution's case. As I indicated to the court, in these tapes, Mark Furman indicates, I am the key witness in the trial of the century. If I go down, the prosecution's case goes down. It goes down, and he says, bye-bye. And that's what they're faced with, bye-bye. They see their case floating out the window because this is a critical witness in their case. And Bailey did a good job of tying it together about whether he had lied. This man has committed perjury. There's no reason to dance around this. He has committed perjury, and that's the issue. Your wife has nothing to do with that at all. They cannot rehabilitate Mark Furman if he uses the N-word 30, 40 times. Margaret York never heard him say that word, presumably. They can't rehabilitate him on that. If he talks about destroying people's driver's licenses and then arresting them. He talks about choking out people because they're black. When he talks about how you stop a black man, and he uses the derogatory term, in a Porsche, and he gives tips for stopping individuals. When he talks about how you lie, how you back your partner up for 6 months, you lie up to 6 months, anything short of an indictment to implicate people. You just arrest them because they're black, and he doesn't use the word black. Margaret York has nothing to do with any of that. They've got to face up to this fact. This is their star witness. They vouch for him. We will prove he's a liar. They know he's a liar. They have an obligation. And it's so ironic, Your Honor, in this case. But Ms. Clark, back in chambers last week, would tell you, we're going to object to the tapes. We reminded her she hadn't heard the tapes. How was she going to object to the tapes before she heard them? Now we find out they're going to object to the tapes. It's like those socks. So that we're troubled by this in this so-called pursuit for justice and honesty. And so what we're proposing is that when the tapes are brought down here this afternoon for you, that the part regarding Margaret York be redacted. There's no reason to get into this side issue. Mr. Simpson is not going to stipulate to any mistrial. Jeopardy has attached in this case. We want to go forward. We want to finish this case as soon as possible. Ms. Clark now adds to the scenario in our latest visit in chambers by saying she can't tell what's going to be material, and some other judge, and you shouldn't tell, some other judge should make that determination. Well, as I told the judge in North Carolina, who knows better what's material in this case than you do? You've been here since September. We don't always agree with your rulings. I mean, that's pretty clear, and I think you accept that. But you know these facts. We rely upon you. Mr. Simpson relies upon you to be fair and give him a fair trial. This jury relies upon it. All of America relies upon this. Another judge who comes in here doesn't know anything about this case at this point, as I saw in the first court in North Carolina. We had to overturn him. So we're saying that you're in the best position. Your wife has nothing to do with this. With regard to Furman rises or falls based upon his own voice, Your Honor. He's the one talking from April of 1985 to July 28, 1994. He's the one using these derogatory names. He's the one who hates women and Mexicans and black people. He's the one who hates all of the commanders. And this case is about real people. He talks about Commander Hickman. He talks about Deputy Chief Frankel. He talks about Daryl Gates. He's talking about his life as a police officer day by day. He talks about criminal conduct by himself and other police officers. This is a blockbuster. This is a bombshell. This is perhaps the biggest thing that's happened in any case in this country in this decade. And they know it. They've got to face up to it. Your wife has nothing to do with that. That's a side, minimal issue. And you should not be persuaded to send this case anywhere based upon that. Because we're not going to stipulate to any kind of a mistrial. We want to go forward. We want our day in court. And we feel most strongly about this. And this, the last thing I want to say is that this whole thing, Your Honor, needs to be unmasked for what it is. And on information and belief, I can tell this court that every file in the LAPD relating to this man, Mark Furman, has been sealed or hidden. Cases that have been settled the last 6 months, the Britain case and everything, you can't find out about them because they sealed everything. Just in the last 2 weeks, a box of files on Mark Furman in Sacramento have been hidden and secreted away. Now, these are the things of a police state, and it's wrong in America for this to be happening, to cover up for this man. Doesn't mean all police officers are bad, certainly doesn't. But when they close ranks and do this, for those people who don't believe that there's been a conspiracy of silence here, this is the ample proof. His voice will give you the proof of what he thinks a real police officer should be and how you stand up. And that's why he believes that women don't count. And so the things that have happened in this case are troubling to this community. And anybody who supports what he does doesn't deserve to be an officer of this court. And so what we're saying is that let's get it out there. Let's lay it out. This is a search for truth. We're not going to hide this anymore. This court should hear it. This jury should hear it. All of America should hear it. And when they do, they'll understand what the defense has been trying to say for all these many months. And so I ask you, with all the fervor of my being in behalf of my client, as we've asked you before, don't send this case. Don't stop these proceedings. You saw our jury. We promised these jurors, Judge, this case would be over in April. It's now August. We're trying to do our part. They took 6 months. We're going to take less than 6 weeks. We want to finish this case. We've only got a few witnesses left, including this thing on Mark Furman. I told you Ms. McKinney is in town. We're ready to call her as early as tomorrow. We're ready to proceed. We want to put the people on notice. We want Mark Furman brought back from Idaho. We'll give them notice right now. We want to finish this case with this jury. You saw them yesterday visibly upset with the cross-examination, and it's time to bring this matter to a halt, not engage in these shenanigans again of sending it out to some other judge who knows nothing about the case. He's going to listen to all these tapes after all this, these hours and hours of tapes. He or she won't know the facts. You know the facts. So isn't our decision or our proposal to redact the portion for Margaret York, isn't that the relevant portion? You've ruled many times against us on this 352 argument. Well, if ever there was a 352 argument of somebody being irrelevant, it's going to be Margaret York, because you can see, what does she have to do with anything? There's nothing to do with that. We're the proponent of the evidence. We're not going to bring her in. They're grabbing at straws when they say they may bring her. And I guarantee you that when this is all said and done, they're going to call your wife in here. They're not going to do it. This is just a ploy. We want to proceed with this trial and get it over with. And we ask you respectfully to do that, to listen to us. We think we're right on this. And this is a matter, I need to hardly remind you, this matter has cost the County of Los Angeles some $6 million. And I think that Mr. Simpson hopefully can get a fair trial and get a verdict that reflects the evidence. And it's too late for them to turn back now. They should have thought about this in that rush to judgment back on June 13th, 1994. But now it's too late. They should have thought about this when they put Mark Furman on the stand. And now it's too late. And we're going to hold their feet to the fire. And no matter where, if the case is sent out, we're going to resist it. We're ultimately going to get back here. This court, this jury, this country is going to hear these tapes. There is no hiding. They can run, but they can't hide. If the court has any questions, I'll be glad to try to answer them.
Yes, Mr. Cochran, I take it, the problem is what you're asking for me to do, though, is to make a ruling on whether or not my own wife is a material or relevant witness.
No, let me correct the court on that. I'm not asking you to make that ruling at this point. What I'm asking you to do, we're the proponent of the evidence. What I'm asking you to do is to receive a redacted version of the tapes. The issue you have to make is whether or not these, what he says is material. When he calls somebody the N-word, Judge, and it's in the last 10 years, and it's his voice, and he's speaking about how he feels about black people. When he says, it's so derogatory, I don't even want to repeat the things.
Right,
when he says those things, that's the issue, Judge. And so, and the racial animus, it fits within your order. It has nothing to do with your wife.
Mr. Cochran, I have to accept, don't I, the offer of proof by counsel, by Ms. Clark, that they wish to offer that testimony. I have to accept what they offer.
No, you don't. I'll tell you why not. Because as you've done so many times to us, Your Honor, this 352, where is the relevance of it?
No, but even the determination of whether or not the offer of proof is sufficient, I don't think this court should be the court to
bear
make
with
the
me just
determination.
1 second. Give me
Sure.
a second. Reminded by my learned colleagues that we just left chambers, and I mentioned this earlier. Ms. Clark says she can't even argue materiality until some judge passes on the issue of what the jury is going to hear, and that's exactly the point. You never get to this. We're the proponent of the evidence. You don't even get to Margaret York. When you rule on his use repeatedly of the N-word, when you rule upon all the times he lies, there's an example on the judge about finding a gun, and you lie and you say you saw a suspect through it, because you know he's probably guilty anyway. You know, that's exactly on point what we're talking about in this case. Or tearing up a black man's license, saying he has no identification. That's exactly on point. Those things have nothing to do with Margaret York. And so she herself said, you said she wants a judge for all purposes, a new judge to come in here or go someplace and rule on the materiality of not only Margaret York, but all of this. And that's preposterous. That's a new position they've carved out when they went upstairs, isn't it? It is. And so what I'm saying, you don't get to that point. Your ruling back in January is the law of the case in that regard, about the things we can do. Now, we may seek to expand it just a little bit by virtue of the fact where he has lied about other things that we can now prove by his word, but that fits within the whole rubric of credibility, which this is all about. I mean, so we're clear about this. And for those people who want to run around talking about race card, somebody need race card. This is about credibility card. This is about perjury. That's what this is about. People should understand that. So we're not asking you to do that. And I am very sensitive, Your Honor, to the fact that your wife is a police officer. We've been sensitive about that since day one. We're very sensitive. But we have relied upon you to be fair despite that. We knew about that first day, did we not? They knew about that first day. We relied upon your integrity. And Mr. Simpson chooses to still rely upon that integrity. What he is saying is that this is not an issue. It is a non-issue being dreamt up by them. You never even get to that. Who in the world could pass upon materiality, which he now talks about, but you? You think one of your colleagues can pass upon materiality in this case? I don't think so. And so that's the issue based upon her new position, that it doesn't make any sense. So when we submit these things to you, you will then see for yourself without Margaret York. And then you will see how under no scenario could they call Margaret York to the stand. Now we have furthermore, let me tell you how ridiculous they are. I'm going to show you something, Your Honor. How ridiculous this is. Early on, when we sent this matter out to another court, and I'll just speak briefly about this because I don't want to infringe upon any conflict area. Your wife was kind enough to do a declaration. And in that declaration, let me just read you just one paragraph so you'll get a sense of how they're not going to be able to call Margaret York. Paragraph 4, this is a declaration of November 21st, 1994. I possess no relevant material or personal knowledge of Officer Furman, nor do I possess any information relevant to this case. Now, that's what your wife said under oath in that declaration of November 21st, 1994. You know, it's grabbing at straws to think now that they're going to call her up there. They're going to impeach her. They're going to impeach her based upon this. I mean, they just can't create stuff like this to try to get a mistrial and throw somebody off where we're on our way. They can't do that, Your Honor. And so that's the point. And
let me just make a comment. I think that when I was contemplating these issues last night, I was concerned that if I had to recuse myself mid-trial, that would be legal grounds for a mistrial, even over Mr. Simpson's objection. And my legal eagles from my law clerk staff found me People versus Espinosa, which is at 3 Cal 4th, 806. It's a relatively recent case written by Justice Kennard and concurred in by all the remaining justices, that in this situation the trial judge became gravely ill and a second judge had to step in and take over the trial. This was a death penalty case which did in fact result in the death penalty, and the judge was replaced midway through the guilt phase. And the court found that there was a legal necessity for the change of judges. However, that in that situation, another judge could then step in and take over the case. If I'm required to recuse myself under 170.1A1, I am convinced that the case law would support another judge stepping in, unfortunately having to take a week to read the transcripts or watch the video.
They will be, Your Honor.
But I don't think I see mistrial as a consequence.
Well, then let me just say this. If there is a mistrial, we believe jeopardy is attached. So if that's what they're hoping for, it's not going to work. We never agreed to it anyway at this point. And we told you back in chambers that we thought that was possible. We know of a case in Las Vegas, as Mr. Shapiro indicated to you, where a judge is indicted during the trial and they bring another judge in, or if someone dies. So another judge could do that. But even if another judge does that, you see, the problem still is, we have an obligation to these citizens over here who've been sitting on this case. We promised to get them out of here. We have an obligation to move this case forward. And I just think who, among your brethren and sisters on the bench, is going to be able to determine materiality or relevancy better than you are, after having been on this case for well over a year now, if the part regarding Captain York is redacted. And that's the point that I'm indicating, because I've tried to indicate to you as clearly as I can, there is no basis for calling her. You know, you heard a number of times our argument regarding something we felt very strongly about, the ability to call these reporters, and something we felt very strongly. And repeatedly you rule It's not relevant, it's not relevant, it's not relevant. I'm telling you, that's not even close. This is not even close to that. It's like night and day. And they're grabbing at straws. And I think you can see from what I've told you. How could Margaret York, based upon your earlier ruling, be relevant in this situation? It's not. So that's just something they brought up. And I just think it's preposterous for us to spend all this time on it. Excuse me 1 second, guys. The final thing I'll say, Your Honor, and thank you for allowing us this time, is that in Ms. Clark's last discussion in chambers, she talked about somebody deciding the overall materiality, perhaps other than you. And we do take great exception to that. I don't think anyone else could do that. I think we just delay the trial unnecessarily. It doesn't make any sense. As regards Margaret York, if one makes the determination of materiality, or if you feel the need out of appearance's sake, without stopping these proceedings, someone I could presume some judge could read your reading, take your ruling, look at it all, and make that judgment that I think they'll of necessity come to, that Margaret York is irrelevant and immaterial. But that way we don't lose, the trial isn't stopped, we don't lose this time, and we don't have the necessary problem. We want a verdict in this case with this jury. Make that clear. We'll be pleased if Your Honor is still here. Be with us on that date. If Your Honor can't be here under Espinosa, bring us somebody else. We want justice. We want it now. It's our client who's been in custody since June 17th, and he's maintained his innocence from that day. And now we can establish that innocence through their lying witness. And they should have known about it. And we found it. And now everybody wants these tapes. That's what we're talking about here. Thank you.
Counsel. Ms. Clark.
About no amount of inflammatory invective, rhetoric, and the persistent press conferences the counsel insists on giving in court can obscure the fact that they want this issue to remain in this court for a very cynical, cunning reason that I do not think is true, but is the problem here. And the problem is this. Given the set of circumstances that we have, the court is aware that there are allegations made. The court is aware of the fact of the statements made by Detective Furman concerning Captain York. The court is not aware of the details. But the mere awareness of that fact creates an appearance that the court may in some way be influenced in one way or another concerning the issues regarding the admissibility of the tapes. That's the legal issue that's framed. The people of this state have the right to expect that we will seek to protect the record in every way possible, regardless of what the fact of the matter is. We know that this court can be very impartial and very unbiased, and yet we cannot possibly say it would be fair to require this court to set aside its knowledge of the fact that some inflammatory statements were made about the court's spouse in ruling on an issue of this delicacy and sensitivity. The truth of the matter is that I think that what the defense wants to do here is hold this issue over the court's head, and the waiver issue as well over the court's head, hope that the court will be inflamed enough by the mere knowledge of the fact of the allegations to either rule that the tapes come in more than it ordinarily would, or bend over backward in favor of the defense to show how fair it can be, or bend over backwards to take revenge against Mark Furman. I think that's the defense thinking here. I really do. And whether it's true or not, that kind of thinking is what the courts have talked about in terms of the appearance. No matter what you do, Judge, you will be criticized because there is an appearance created, and it's a no-win situation.
Well, that's pretty much par for every day, isn't it?
Yes, I agree. I mean, and I think that may be true for quite a few of us here. And the court has my sympathy in this very unusual and difficult situation. But it is not a situation that is made easier on this court or made more appropriate by counsel's rhetoric and the constant pointing of fingers and the constant allegations of lying witnesses. Now, I think it's very interesting that counsel has repeatedly said they don't want a mistrial. The people have made it clear. We want this jury to decide this case as well. In whatever manner we can, we don't want a mistrial. I don't want there to be any mistake about that, because the families of these victims have had their lives on hold for long enough. We hear about Mr. Simpson and his rights. I never speak in derogation of any defendant's rights, and I will certainly not do so here. He has the right to a fair trial, and a speedy one. And I agree. So do the families of the victims. They have rights here, they have feelings, they have suffered, they have grieved, and now they're being put through this trial on national television to grieve publicly, when at least most families of victims can grieve in their private homes. They have had to be exposed on national television with every horrible issue, every single argument, every single thing that comes up with every witness they've had to suffer through it. The court has seen them here. They have a right to have this jury hear this case and have it resolved. Now, we, in all fairness, counsel keeps talking about who got the tapes. The court is aware of the fact that as soon as the people were aware of those tapes' existence, and that was very recent, we sought to get the tapes. We sought the guidance of the court. We asked to issue an SDT.
I recollect Mr. Darden's
Yeah.
1054.7.
So I just want there to be no mistake on the record that Mr. Cochran, once again, is trying to mislead everyone in saying that we tried to hide the tapes, that we had knowledge of them. No, we were out there looking for them first, the minute we found out. So I just want the record to be very clear about that. Mark Furman's characterization of his role in this case, whatever that may be, is so irrelevant as to be laughable. Whatever he thinks, however important he thinks he is, we all have a sense of importance about ourselves. Some of us are a little bit too low, some of us are a little too high. Doesn't matter. The bottom line is, what is his role really, not what he thinks it is. And counsel knows that. Counsel also knows very, very well, as this court does, that we didn't need to call Mark Furman at all as a witness in this case. We did. Complete the picture, we call all the relevant witnesses, whether they are absolutely legally necessary or not. Now, the fact that he was called to testify does not mean that we characterize him as being the key witness in the case. He found a piece of evidence. What we vouch for, in terms of Detective Furman, in terms of everyone in this case, is that no one planted any evidence at any time. There has been no false statement made about where that evidence was found, the analysis of the evidence, or its results. And the defense wants to squirm away from that fact by playing the race card. We don't want to do that. We've never wanted to do that. We know what a search for the truth means, Your Honor. We know that the truth we are searching for is who murdered these people, not who is Detective Furman. If there was any opportunity for anyone to plant that evidence, to plant that glove, it would be a different story. A totally different story, but there wasn't. The defense knows that. And they're caught between a rock and a hard place, because no matter how badly they want to paint somebody to be the villain in this case, other than their client, the truth of the matter is all of the arrows point to the defendant, because that's the mountain of evidence that exists that he cannot get away from. There was no opportunity for Mark Furman to plant the glove. And so whatever his personal beliefs may be, which we may or may not know, the truth of the matter is he could not do what they're trying to prove he did. And now that the evidence has come out conclusively, irrefutably, and consistently that there was no opportunity to plant a glove, they are just going all out to smear Mark Furman in the very cynical and shrewd effort to pull this jury away from the evidence, to manipulate them, to play them like fiddles, and to say, ignore the evidence. We know we haven't proven anything to you. We know we have failed to prove a conspiracy. We know that we can never prove anybody planted the glove, or the blood on the socks, or the blood on the gate. We know there are pictures of the defendant wearing the gloves of the exact same type and model purchased by Nicole just 3 weeks after the purchase that are the exact same type and model as these crime scene gloves. Don't look at that. Don't look at that. We have a big bad boy for you here who said terrible things and possibly done terrible things. That's what's important here. It would be if he could have done anything to impact the evidence in this case, but he could not. And that's the truth of the matter. And they want to manipulate this jury so that they will not look at that evidence, so they will look at only the villainous accusations made against Detective Furman, and if they're true, then it is very bad. And that is another search for the truth. The truth we are searching for here, right now, in this case, and I agree, Your Honor, let's try the Simpson case, is who killed these people. And we know it wasn't Detective Furman. Whatever Detective Furman has done in his past is not part of this case, because he could not do, and we know it now, and they know it too, he could not do what they wanted to prove he could do. So that's fine. We can all search for that truth after the fact.
All right, let's circle back to the issue that's presented to the court, however. You've indicated that you feel somehow that Captain York will be a material witness in this case.
This
So
could-
isn't that a preliminary fact or preliminary legal determination that has to be made at this point?
Well, no, see, and that's the problem here is that we need to make something, we need to find out what is going to be admissible before we will know how to respond. It would appear, based on what I've seen in these transcripts, and I've read them all, that it could very well be that Captain York will be a rebuttal witness depending on what is deemed admissible. If a court rules that none of these tapes are admissible, then obviously she's not needed as a rebuttal witness. If the court, on the other hand, rules that much of these tapes, with their inflammatory language, is played in front of this jury, and make no mistake about it, if you have any doubt that what this defense wants to do is inflame the passions of the jury and cause them to look away from the evidence, you only need to refer to Mr. Cochran's remarks when he said to you just today that the remarks are so derogatory he doesn't want to repeat them. I agree with him. I don't want to repeat them either. And I don't want to repeat them in front of this jury either, where they have no relevance. But until we know that, how do we know how we're going to respond?
Then let me ask you this question. Who should make that determination and why?
I believe that in context, knowing that what we do, I mean, the court is already aware that there are negative comments made by Detective Furman about the court's spouse. I think that knowledge requires that another judicial officer determine what is material, what is relevant, what is admissible in terms of these tapes. At that time, we'll be able to determine what the people's response will be, or potential response will be. But until that determination is made, and I think we can't know. Now, what I was starting to address to the court was the issue of the appearances, and the sections and the brief that I have a draft of but has not been finalized yet frames that issue very squarely. And that is when there's even an appearance that there might be an impropriety or there might be a bias, then it would be appropriate for it to be referred out to another judge. Now, that doesn't mean, and in my opinion, that is a limited thing. That would mean that another judge makes the materiality call, but then we can come back.
But I just want to suggest to you that as a practical matter, I'm wrestling between the offer made by Mr. Cochran that this court make the admissibility determination of all the materials with the exception of what refers to my wife, that being redacted, versus, and then because this court is obviously more familiar with the issues and the facts and events of this case. As a practical matter, since you raised the appearances problem, and I agree that's a very wide penumbra that comes with that, and I'm very sensitive to that, as I must be. As a practical matter, it's going to take another judge will have to read Furman's transcripts, will have to make reference to other issues in the, will have to read other witnesses. For example, Detective Lang's testimony regarding his then going outside and seeing the glove as he was directed by Detective Furman. He or she will have to read Cato Kalin's testimony regarding the conduct of Detective Furman. I suspect a Lexis word search through the transcript where Detective Furman comes up will likely involve, perhaps, my guess is that another judicial officer working full-time all day, every day will take a week to resolve this issue.
That may well be, Your Honor. The problem is, though, that I really don't see how it could be, it just does not seem appropriate under the wide berth of the appearance of impropriety standard for this court to resolve that issue, knowing what is hanging out there in terms of Captain York and the possibility of her being a material witness, and the allegations that the court has the knowledge of the fact of, if not the details. And I cannot see how it could possibly be appropriate, although I understand we have a problem with another judge having to spend considerable time to get up to speed. It can be done. And I think that in all fairness to all parties, and especially to this court, it would be a matter best left to the auspices of another court where there can be no allegation that there is any motive to do anything either to bend over backwards to preclude the tapes or to bend over backwards to admit more of them. It is really a no-win position for this court, and I think that it is not one that was contemplated as for any court to undertake. And that is why they have the broad standard of the appearance of impropriety as it is.
Let's assume that I accept your argument concerning the breadth of the appearance problem. Are you prepared to, on behalf, or you might want to contemplate this, are you prepared to go forward with other witnesses?
I think that we could. I don't see why not, and I'd really prefer to do that, Your Honor, rather than lose time with this jury. And let another judge get up to speed on those issues, but I don't see why this court could not continue to hear the rest of the case. And that would be a much more effective use of time.
All right, do you have any other comment, any other suggestions as to what we ought to do
May I
here?
have a moment, Your Honor?
Let me see counsel without the reporter, please. Ms. Clark, you had some additional citations for the court?
Yes, I do, Your Honor. Let me cite to the court Flyer versus Superior Court, 23 Calat 4th, 165 at page 170, and indicates that it goes into 170.1C, or, excuse me, is it, I think it's C. A6C. A6C. Quote, the standard for disqualification provided for in subdivision A6C of section 170.1 is fundamentally an objective one. If a reasonable member of the public at large, aware of all the facts, would fairly entertain doubts concerning the judge's impartiality, disqualification is mandated. The existence of actual bias is not required. And that's basically the situation that we're confronting here today. What the court is aware of is that nothing in this case has ever been kept under wraps, no matter how diligently we have attempted to do so. And in this particular case, we have parties that are not before this court that are in possession of much of this information who may have a real interest in putting out little snippets of information to tweak the interest of the public. The allegations made by Mark Furman concerning female officers and Captain York will undoubtedly become a matter of public knowledge. I have never been surprised in this case since, I guess, September or October, at all the things that do come out, whether they should or not. This will, I'm sure, be no exception in either large or small part. That's the only thing we don't know is how much will come out. But we have the additional issue here of the fact of a detective on whose credibility the court will rule in terms of the evidence that will be admissible, who has made allegations about other female officers in addition to Captain York. So we're talking about an awful lot here that can be, at least to the public at large, something that would cause them to entertain doubts concerning the impartiality. And I think that under this circumstance, Judge, how can you possibly avoid criticism no matter what you do? And I realize that the court has been in that situation before, but I think in all fairness that this is one that is unfair to put on the shoulders of this court simply because of the fact that there will be nothing that you can do. And the materiality issue, well, with respect to what is admissible, we can't put the cart before the horse. So I know that another judge will be hard-pressed to go through everything, and yet
a tremendous burden on some other court.
it is. I can't deny that, Judge, but I think it's something that we have to do. We know that there will be no mistrial. We are aware of that. We went upstairs, we researched the issue, and we realized that there is no danger of that. And so that was never a concern, and had it been, we would have had to confront something else, but fortunately, we don't.
All right, just for the record,
And there is another
I'm sorry.
option.
I just wanted to mention that the language that you cited to me in the Flyer case actually quotes the United Farm Workers. It's a quote from the United Farm Workers case that I cited to you.
Right, and we have that one as well, Your Honor. So it's obviously a well-known, well-read passage. But there is another way to resolve this. If the defense wants to withdraw the race card, we have no problem and no issue, because that is not an appropriate thing to have been injected into this trial, and it has been repeatedly by counsel. If we could just try this case on the evidence and the facts, we wouldn't be confronting this right now. This is something that has been injected into this case in a very shrewd manner by the defense. And if they want to withdraw that now and finally try this case with this evidence and these facts, we can obviate the need for all of this.
All right. Thank you, Counsel. Mr. Cochran, I'm concerned about the appearance argument that Ms. Clark makes.
May I address that?
And I'm concerned, it concerns me because of the argument that this court, in making a ruling on the overall materiality of the tapes, might be motivated to punish Detective Furman for saying these things about the court's wife, therefore giving a broader range of admissibility. Or it could be argued in the converse that the court might not want this kind of stuff to come out and would not want the court's wife to be embarrassed or to be put through the public spectacle of being part of this trial. I mean, that could cut either way, and the problem is it's not that any of that is true. And you know, as professionals in this field, we know that things are said about people all the time that are not accurate, not kind, and oftentimes disparaging. And I know that women who operate within male-dominated professions and who are successful are always targets for this kind of treatment. And it's something that you live with and you adjust to and you overcome. But the problem is the appearance is what concerns me.
I appreciate that, Your Honor. I appreciate that very much, and I welcome the opportunity. I will not be long to address those issues that you've raised and a couple of others. With regard to this idea of appearance, Your Honor, you've been married to Captain New York for a number of years before this case. Some of us, at the outset of this case, remember back in Department 100, believed that you could be fair despite that you had integrity. Each step along the way, as I recall, you have told us when your wife was transferred, she was in bunco forgery, I think, and then she was transferred to Internal Affairs, and we may have concerns about her being in Internal Affairs, but we didn't have concerns about your integrity and your fundamental fairness in this case. As I pointed out before on this idea of appearance, the people are somewhat hoisted by their own petard. On the one hand, they want to have it sent out to determine the things on Margaret York. On the other hand, they say, well, now we want somebody to determine all the materiality. And that doesn't make any sense, because you don't have a conflict regarding all the other materiality, it seems to me, so that at least you should make that determination. I didn't hear a good answer from Ms. Clark regarding that. You would be in a position to best make that determination. Judge, Let me just tell you, Mr. Blazer was kind enough to run on his computer. Mark Furman's name has been mentioned 1,813 times in the transcripts in this case. You don't think he's key to this case? It's not only in his mind, it's in their mind, it's in everybody's mind. He's key. They want to wipe him away, of course. They didn't call Dr. Golan. They can wipe people away, but they're not going to be able to do that. And so the judge, the point is, this is critical. You can't just read Lang's 9 days of testimony, another judge, and get up to speed. You've got to understand what Lang and Van Adder and Cato Kalin said. You got to understand, Judge, how important this witness is, because remember, they talk about not planning stuff. Preposterous. This man goes off by himself for 15 minutes or more, and then he supposedly finds his glove. Judge, this is after he's been taken off the case. It's not his case anymore. So, you know, I'm not going to argue that, because that's preposterous what she was saying. And a jury will make that determination. But this man, you have to get all of the facts to understand Furman's involvement. And so, you know, the thought that some other judge is going to decide materiality based upon the ruling you made back in January is preposterous. And it's unfair to the whole system. And furthermore, you know, there's another punishment I thought about when I was sitting there. This jury is going to think the defense is holding this up. And again, it's the prosecution. By this frivolous attempt here, by trying to stop the proceeding. This is during our case, not during their case, because they want to avoid what's coming. Now, let me just address a couple other things, Your Honor. Counsel talks a lot about, she made a number of statements, which I won't even bother to dignify. With regard to these tapes, I should point out to Your Honor that they may have talked to Your Honor in chambers, but they didn't go to North Carolina. They didn't do any of that. We're the ones who did that. And he's their witness. So, I mean, let's make the record completely clear. She talks a lot about this idea of a race card. And we take personal umbrage to that. Because, as this court knows, credibility is the key of every case. Calgic 2.21, et cetera, says, a witness materially false in one part can be distrusted in others, unless the greater probability of truth lies in their testimony. So, Judge, this is about credibility. It's not about race. I happen to be black. He happens to be black. These men happen to be white. What difference does that make? We're all still Americans. The question is, in this case, credibility and whether or not this man has lied under oath, which the tapes will show that he has. So she talks about withdrawing the race card. That's preposterous. You know, withdrawing anything. She'd like for us to do that. We're not withdrawing the credibility card, because that's what this is. And so that was a nice move, but it's not going to work. And now, in addition to that, Your Honor, let me come back and end on this note about Captain York. It seems to me that a reasonable and a wise way out of this is for us to continue with this case. The defense, Mr. Simpson shouldn't be punished because they have this frivolous motion. Another judge is going to take, I think you're being very kind. A week is going to be very long. You know, most courts, unfortunately, don't work as hard as we work in this court. So it's going to take a judge from 9 o'clock in the morning until 9 o'clock at night, longer than a week, to read all this testimony, to understand what this case is about, to become familiar. When you could rule on materiality, because we're going to submit to you tapes that have nothing to do with your wife. If at all. She's talking about this coming up in rebuttal, because that's the only time they get back up. So how do we even get to that issue? Because it's going to become very clear to everybody that that's never going to be an issue. Your wife has nothing relevant to say. Are they going to say, Judge, let's think about this for a minute. Is Marsha Clark going to have the gall, after we play these tapes for this jury, to stand up before this jury and say, well, he didn't use the N-word. He didn't talk about throwing people downstairs and breaking their necks. He didn't do all that stuff. And Margaret York can tell us. That's preposterous. That is preposterous. It's not going to happen. You know it's not going to happen. And so out of an appearance, because you want to be fair, but you know what? Let me tell you something. When you get in the kitchen, you stand the heat. You've said that before. You stand the heat every day. It's not going to be popular. We're mad at you one day. They're mad at you one day. Somebody's always mad at you. And so you understand that. But we handle it with respect, and we come back the next day.
Well, I must be doing a pretty good job.
Yeah, somebody's always mad at you. Well, that's for sure. And the question is, are you even-handed when you pass out these things? We talked about that yesterday at the thing, and are you even-handed? That's all we've ever asked for. We just want you to be fair to both sides. And you are in a best position to be fair on this issue of materiality. Another judge, it's an unfair burden, and they just can't do it. So we don't even get to this point about rebuttal until that point. And Ms. Clark does admit, let's go on with the trial. But the problem with going on with the trial, Judge, as you recall, we give them our witnesses, and we have, as you know, we'd like very much to finish Ms. Kessler, and then we have Mr. Regal, And then we're right up against McKinney and our ability to play these tapes. And that's what we want to do. We want to proceed with our cross-examination at that point. And I'm telling you that when the part we submit to you will have nothing to do with Captain York. We don't want to play anything about Captain York. This is our case. What do you always say? We have a right to try our case the way we want to. Now, if they want to deal in some fantasy land and try to figure a way to bring your wife in, it'll become clear not only to you, to this jury, but everybody in America that that's just folly. And it's not going to happen, I'm telling you. So why do we have to go through this in the first place? So when you get back to the idea of appearance, it has to make some sense of an appearance. The only reason you know about your wife being in these tapes, you know why? Because yesterday, Ms. Clark went up there and told you about that. We didn't tell you about that. They told you. She brought it up. And then we confirmed certain things, but she was the one who asked to tell you about that. Now, I don't think that's relevant because we had made a decision among the defense that it wasn't relevant. We aren't going to offer it, so why would we even be going into that? It has no relevance. And that's the point. That's where we stand now. We have no relevance. So we find ourselves in this unique position where the defense is saying to a judge who's married to an LAPD captain, you go forward because we think you can be fair in this particular. We think even more than that, you've shown with regard to your ruling in this case, which is somewhat the law of the case. And when you look at that ruling, it's pretty clear about the things we'll be allowed to do. This is not a big issue. You know, they've tried 402 motions on every witness we had in their search for truth. But the law is already set out pretty much on what we can do with Furman. And that's why these tapes are so very, very important. It's spelled out. It's right. I mean, Judge, if you were a lawyer and you went to sleep and you dreamed about something happening and you woke up, you couldn't have asked for more than to have the key prosecution witness on tape for 10 years talking about the things this man talks about. And when I talk about that, it has nothing to do with your wife. I mean, as I said, he doesn't like anybody, but specifically he doesn't like black people. And specifically he likes to frame people. And specifically he lies when it suits his fancy. And he was their witness, and this is about credibility, and you can't wipe out credibility. Because that's the key to this case for everybody, is whom are you going to believe? It's not Miss Clark's theories. She throws out all these theories about gloves. That's just for the press. They can't prove anything about any gloves. They can't prove anything. They would have proved them before. It's just speculation. And at the end of this case, Judge, and things haven't gone well, and they're trying to figure a way out, but they're not going to get out because you know what the facts are. And I'm just saying on this whole idea of appearance that I think you'll be fair. I don't think you're going to bend over backwards either way. I mean, I think you're going to call it the way you see it. I mean, I would expect nothing less of you. Otherwise, we wouldn't have been here in the first place. We'd have gone someplace else. So we want to finish this case with you, but we want to finish this case regardless, with or without you, as I said before, and we hope it's with you. But just remember the burden they ask you to place upon one of your colleagues for no good reason. 1,813 times Furman's name is mentioned to this point. Think somebody's going to get a flavor for that? Reading the testimony, you think they're going to get a flavor for Bailey's cross-examination, how important this is? And then way off in the distance is the specter that, gee, we may think of a reason to call Margaret York so we can get you off the case or get some other judge down here. Why would they be doing that? They worried about you all of a sudden? Your appearance? Well, we're saying there is no appearance regarding the materiality, the overall materiality in this case. That the only appearance is that you're the one best suited to do it. That's the appearance we're faced with. And as to the other, if it comes up at that time and you feel some question about it, then deal with it back then. Deal with it on the back end when we get to that point. But I think after you rule on what's relevant, and we're not asking for Margaret York, and it's not their case to ask for it, so it's in our ballpark, we don't even cross that bridge. How many times do you tell us, counsel, you're premature? They are premature at this point, and it will probably never, ever come up. So I respectfully ask you to, let's go on with this case. The jury has a right to hear these witnesses and have a right to get this case and make a decision. May I have a second, Your Honor? Reminded of two things, and I'll be concluded, Your Honor. I think that the court has already, in fact, reviewed certain internal affairs files on Furman, I believe. I'm pretty sure about that. I know you conducted a hearing regarding the district attorney's office and their prep session of Furman, where they're all present, they sat around and, you know, in the grand jury room. So you've done those things. I mean, there's so many things that you've done already. Where nobody was worried about any appearance of conflict at that point. Your wife at that point was, I think, assigned to internal affairs. We didn't raise any issue at that point because we've trusted you, Judge, all along. I don't know where their trust went along the way. All of a sudden, they're worried about some appearance, and the appearance doesn't even show up at this point. Mr. Simpson, if the court will allow me, wants this court to be aware of the fact that certainly he, along with all of us in this courtroom, his heart goes out to the families and the victims of this case. He is also a victim in this case. And so when Marcia Clark makes those statements, don't for 1 minute misunderstand our sensitivities. We've tried to conduct ourselves in a way throughout regarding the families of these victims. But we have a man who from the very beginning has maintained his innocence. And he is troubled by what the so-called authorities have done to hide and cover up for this Detective Furman. Somebody out there, Judge, should do something about this cover-up. Somebody should do something about all these files that have been hidden and sealed. This is still America, and that's unfair. And we think it bears directly upon Furman's activities in this case, other cases, and it has a direct bearing on OJ Simpson's innocence. And he has maintained and continues and will maintain his innocence till the day he dies because he believes that the facts will show that, and in fact, he is innocent. He wanted me to indicate that to the court, that there's not any lack of sensitivity at all on our part at all. But he too has become a victim in this rush to judgment. And so he wants his day in court, and we want to proceed and do that. Thank you very much, Your Honor.
Thank you, counsel. Briefly.
We heard no cases cited by counsel. Counsel cites to a frivolous motion. It's his motion. It is counsel's desire to get these tapes before the jury, and I agree, it's frivolous. There is no cover-up going on, Your Honor. We're not, you know, Mr. Cochran cannot presume to think for the prosecution. He can't get into our minds or our offices or our briefcases and tell us who we can call on rebuttal and who would be appropriate. And, you know, I think that we know how to try our case a little better than he does. And what is the appropriate witness to call in response to whatever they may be permitted to do is something that we have to determine. And this is something that we will determine only after we know what is relevant and admissible. But what Mr. Cochran is very insensitive to is the position that this court has put in and the appearances that are going to be created if this issue is left in this court at this time. The rules of judicial conduct also require that the court always remove from itself from any possibility of an appearance of partiality or impropriety. And now Mr. Cochran is trying to lure this court into abandoning that code of judicial ethics. This court knows what the reality is, and the fact of the matter is that's why the cases talk about the appearances and not the actual proof of such a thing. Mr. Cochran and his team, I am sure, are hoping and calculating that you will be biased, Your Honor. That's the point of this kind of situation. Whether you actually ever do that, and we do not believe that you will, but whether you actually do at some point or not, that is their hope and their desire. That is the motive here. That's the target. Must make no mistake about it. And whatever you do, however you rule, there will always be the appearance that somehow they got their way, perhaps. Or that perhaps the opposite. You leaned unfairly on them to avoid that appearance. No one will ever know because that appearance does exist. That's the problem that we face with this situation. They have the opportunity to obviate the whole thing, but they have made it very, very clear the way they want to try this case. They've been doing it now for almost 9 months. They're not going to stop. It's going to be up to a court to stop them. The press conferences, the invective, the allegations, the untrue allegations. I wasn't talking theories when I said nothing was planted. I'm talking fact. I'm talking evidence. I'm talking what witnesses have said under oath. They've got nothing of the kind on their side. They have allegations, they have empty theories, they have conflicted theories, contradictions within their own theories. It's nonsense, smoke and mirrors again. We're used to it. We're old hands at this. We've seen this for how long? 20 years now? The defense always gets up and puts on this smoke screen like an octopus. You get too close. Out comes the ink. This is their ink. This is it. I am not saying that Mark Furman should be painted as a god or a hero, but he's certainly no critical witness, as counsel keeps insisting. And whatever is determined, I hope that this jury, and I have faith that this jury, is not going to be as easily played as counsel anticipates or as counsel plans. Nevertheless, counsel has failed to give this court any case authority or any factual authority or made any offer to stipulate in any way, shape, or form or issue a waiver that might make it possible for this court to hear this issue. And in light of that fact, Your Honor, we are left with the problem that we are left with. And I don't see how the court can do otherwise than have the case sent to Department 100.
All right.
Before you do that,
Thank
Your
you,
Honor,
counsel.
I'd like to ask Mr. Douglas to call Mr. Dershowitz, facts machine messed up. We want, before Your Honor makes any final thing, a chance to get some cases for the court. As you know, during the break, we did speak with Messrs. Dershowitz and Jerry Ullman. And so we'd like for you to have those before you make any final ruling.
All right. I was anticipating taking the matter under submission, doing some research over the lunch hour, and ruling this afternoon.
We'll have whatever you have by that time, Your Honor.
All right, Ms. Clark, if you have some other authorities, you can give it to Mrs. Robertson.
Thank you, Your Honor.
That'll be fine, Your Honor. Your Honor, can I say one last thing?
Yes. No, actually, no. I've heard enough.
All right.
It's just that naturally polite
I'll
reaction
stay.
that I have.
Your Honor, do you want to wait on other testimony until you resolve this issue? Okay.
I think we need to resolve this issue
Okay.
first. This is sort of, I'm required to rule on this issue once it's been presented to me, and that takes precedence over all other issues. So this has to be determined at this time. All right, we'll stand in recess till 1:45. All parties and counsel are again present. The jury is not present. Sorry to see the district attorney can't pay their lawyers enough to buy jackets.
One is being sent out, however, Your Honor.
All right. As to the recusal issue, actually, I see we have Mr. Schwartz and Mr. Regwan present in court. Counsel, yesterday we had counsel for Mr. Furman in court yesterday asking for the court's assistance to get copies of the transcript and the audio tapes. It's my understanding that your client is willing to display the transcript to Mr. Furman and to make available for their listening the tapes. However, you are not willing to provide any additional copies, but you give them the use of your conference room if your office to do that. Is that correct?
That's correct, Your Honor.
All right. I'll have Mrs. Robertson then communicate that to Ms. Butler and Mr. Tortolo. All right. If we have your card, correct?
I have another case.
All right. All right. Thank you, gentlemen. Appreciate your cooperation on this matter.
Your Honor, they're here for also another reason.
No.
Let me just indicate that. We asked them to get out.
They have the, pursuant to the subpoena that we obtained in North Carolina, the one you issued, they have the tapes. And what I would ask the court to do is have them leave them with the clerk, and I've asked for some further time to discuss a proposal I have for the court. Just put in Your Honor's clerk's custody at this point, and then we'll address the issue of redaction after that.
All right, then, gentlemen, at the conclusion of the session today, I'll direct you to turn those materials over to Mrs. Robertson. Mrs. Robertson, I'll direct you to place those items under lock and key. All right. All right, Mr. Cochran, you said you had some other proposal?
Yes, I do. I have proposed to the court that may save some time. And I wanted to get this to the court. First of all, Your Honor, we used our time hopefully wisely over the lunch hour with regard to these tapes. The Laura Hart McKinney tapes. And what I'd like to propose is an offer of proof. This is our part of the case, and I'd like to propose an offer of proof, which I think is appropriate under the circumstances, and share some additional facts with the court. I'd like to further back this up with a written, detailed offer of proof, which we'd be prepared to file with this court by tomorrow morning. But I can tell you pretty much what it is. We spent the time researching. Let me proceed as follows, if the court pleases. As far as Mr. Simpson and the defense, we contend we should be allowed to proceed as follows. We have checked these tapes out, and there are at least 30 times when the so-called N-word is used to refer to either suspects, regular citizens, city council people, anyone in disparaging terms. There are at least 17 instances in these tapes in which Detective Furman admits or approves of planting, manufacturing evidence, lying, or covering up police misconduct. At least 17 instances. And in one instance, he describes himself as a key role in covering up a situation, Your Honor.
Well, Mr. Cochran, forgive me for interrupting you, but this is sort of the offer of proof that you need to make to the person who will make the materiality call.
Well,
so I thought you were going to propose another method of evaluating that issue.
Well, I will do that, but I'm saying to you, once you hear this offer of proof, it's back to our additional position I made this morning that there's no reason to send it out. And if you do send it out, then send it out only, here's what we propose. Assume arguendo that based upon this, the 30 instances of where the N-word has been used, or at least 17 instances where this officer has talked about lying, covering up, beating people, and that sort of thing. Subsume that that is relevant, okay? Then, under that scenario, let them argue that Margaret York is material. Because you're going to say, we're going to waste all this time. I mean, in L.A. County, I can't believe the Board of Supervisors are hearing this. They must be really shocked out of their minds, because how could you then pull a judge off another case, ask them to read this entire transcript for something they will never be able to get in? This is a waste of time. And it's ironic that we're the ones bringing this up, it seems.
Mr. Cochran, here's the problem. The problem is this. They raise the argument. They raise the issue that because the court is now aware, based upon the offers made both by you and by Ms. Clark, that Mr. Furman has made comments disparaging of this court's spouse, would a reasonable person with those facts suspect that the judge might have difficulty in being fair in evaluating the materiality of impeachment testimony with regards to the person who was alleged to be making these disparaging remarks?
Well, let me answer that. Well, you know what? When I told you this morning how this man disparaged everyone, went back through the transcripts also. Well, you're not going to be able to send it seems to me, necessarily to people in this county. Let me read something for you. Quote, may I, Judge, I'm up to discussing. May I proceed? May I proceed, Your Honor, please? Every judge of the Superior Court and Supreme Court, I don't know what the Supreme Court or the Superior Court says, and I really don't give a blank. That's how he refers to Superior Court judges in this county, and to politicians and everyone. He has something for everybody. So, I mean, it may be your wife, but he has just as little regard for Superior. I suppose that a judge who sits and listens to that on the tapes, and I quoted from the tapes, they're not going to be very pleased with this man either.
But the problem is, my wife is apparently referred to by name, by rank, and by
She is.
Assignment, contact with this person.
She is, but I think that he also refers to Superior Court judges in this county. He has no respect for anyone. So I'm just pointing out to you that it's not going to be easy for you. If you want to send it to a woman, he doesn't like them. You want to send it to a black, he doesn't like them. You want to send it to a Mexican, he doesn't like them. He doesn't like anybody. Doesn't like Jews, doesn't like anyone unless they're white Anglo-Saxon police officers. And that's the problem in this case, Judge. And so I just wanted to point that out to the court.
All right.
Now, and so let me just pose this as a fallback. I don't think you should send it anywhere, because I think it's a waste of time. If you are going to send it anywhere, then I think the court should carefully, and with the assistance of counsel, tell this jury something about this delay that is not the defense. Number one. Number two, if you're going to send it anywhere, you should send it only under the scenario I talked about, that you assume that what we've said is material and relevant, we'll prepare something in writing. Then let the people put up or shut up. Let them talk about how your wife could possibly be relevant. If the judge finds that Margaret York is not relevant or germane, even in rebuttal, then send the case back. And then we get on track and keep going. That's what we're trying to say, Judge. You understand what we're pushing and trying to say. And I think that, I hope I succinctly have stated this as well as I can, but I'm telling you, you're going to have a problem no matter where you send this case. And without going into more detail, that's what we propose. May I have just a second, Your Honor?
Sure.
Just two final points, if I can, Your Honor. We feel really strongly and unanimously that this issue about your wife is made in bad faith and it's a red herring. It's going to come back and you're going to see it. There's no way they can do it. They know the things that, there's all kind of ways that what Furman says with regard to even Your Honor is not going to be relevant at all. But I want to make sure the court understood what I was saying if the matter is referred out on a limited basis. If you assume these items are material, the other judge, without reading everything, then he has to address, once we lay it out, their argument regarding materiality regarding your wife. If they don't, if the judge, and of necessity, the judge must, it seems to me, find that to be irrelevant and material, then it comes back to you without any further delay. Then you make the determination of what the jury gets to hear. I want to make sure that was clear as to what I was proposing.
All right. I understand that.
Okay, understood. Okay.
All right.
Very well. Thank you, Your Honor.
Well, Your Honor, the people have done further research over the lunch hour. And, counsel mentioned red herrings, and it's real unfortunate, but this is a red herring that has really skewed this entire trial. And it's the defense making. One of the incidents that has racial undertones to it directly involves Captain York. It'll make the rebuttal extremely germane, and it goes right to the heart of the issue. As I framed it in chambers, counsel will not be able to resist the relevance of the rebuttal on grounds that it's only sexism. And for myself, I don't call that only, but in this context, one can understand it. It's not. And that very incident kind of describes the entire people's argument as to why these tapes should be deemed inadmissible, as to why they're not material, as to why this is a red herring. And we will be forced to put that on in response to the defense use of these tapes. The issue, unfortunately, cannot be confined solely to the witnesses pertinent to the tapes. We researched 170.1, and under 170.1A6C, as I've cited to the court, this court would be ruling on the admissibility of tape evidence where a person aware of the facts might reasonably entertain a doubt that the judge acted with impartiality. That's the position the defense has put us all in with their insistence on making these tapes the cornerstone of their case. If this court heard and decided the admissibility of the Furman tapes, a reasonable person could conclude either that the court ruled inadmissible, otherwise inadmissible evidence to spite the detective who has made disparaging comments against the court's spouse and female LAPD officers in general, or that the court excluded otherwise admissible evidence from these tapes to the detriment of the defendant in what could reasonably be perceived as an effort by the court to protect his spouse. That's the situation that the defense insistence on the use of these tapes has put us in. The people submit that it's critical at this time to step back from the emotionalism and the fiery rhetoric of this morning and to look at this issue from a purely legal standpoint and to recognize and reaffirm the need to protect the institutional integrity of the judicial system. And this principle forms the core for Code of Civil Procedure, Section 170.1A6C. And it's a principle of such magnitude and paramount importance that it supersedes any other considerations. We note that under Section E of Canon 3 of the California Code of Judicial Conduct, it requires that a court disqualify him or herself in a proceeding in which the judge's impartiality might reasonably be questioned. The commentary to Section E indicates that under this rule, a judge is disqualified whenever the judge's impartiality might reasonably be questioned or whenever required by the disqualification provisions of the Civil Code of Procedure. And the problem that we are faced with, and the reason that the test is that it is not actual bias, but the appearance of bias, is that it is the appearance of impartiality by the judicial officer that is of paramount importance in our judicial system. With their insistence on the use of these tapes to put into evidence one of the biggest red herrings that has ever been seen in the course of jurisprudence, they have forced us to litigate an issue that directly involves the spouse of this court in multiple ways. And whether there is actual bias and whether this court will be able to actually set aside its bias is no longer an issue because the appearance has been created. And so what we are talking about at this juncture is that there is no ability to sever the issue and say, this is it, and we'll take only this issue out and then come back. Because the situation that has been created now is that all rulings with respect to Furman witnesses become suspect in view of what we know to be the case in terms of allegations made by Detective Furman. Certainly it's framed squarely and completely with respect to the tapes and the issue of their admissibility. And then, of course, again, with respect to the admissibility of rebuttal testimony by Captain York. But it spreads out to all the witnesses that would be called concerning Mark Furman. All rulings at that point will be looked at from the point of view, well, we know why he let the witness say that. After all, he knows what Mark Furman said about his wife or all female officers. That's the situation we're put in now. Very unfortunate. I offer the defense again an opportunity to try this case on its merits and on the evidence that's relevant to the facts, that is relevant to the events that pertain to the murders of these two human beings, and that if they feel it's necessary to vilify Mark Furman, surely the biggest red herring that ever was, the people offer to stipulate that he used the word in 85, 86, and 87. And I think that fairly gives them the opportunity to impeach him on a matter that is collateral at best, and yet would allow us to proceed with this trial without the need for total recusal. I take it by Mr. Cochran's rhetoric that a reasonable alternative such as the one I've suggested would never be acceptable to him. But I make it nonetheless.
All right, counsel, I think I've heard enough argument.
May I just respond to that?
No,
Just briefly?
no, Mr. Cochran, no, I've heard enough. I've heard enough. Thank you. Thank you. All right, under our Code of Judicial Conduct and also the Code of Civil Procedure, judges are under a direct statutory and ethical obligation to decide all issues that are presented to them. I am very reluctant to send this matter out to another court for two reasons. One, it is an incredibly onerous burden to ask another court to make this determination, both from the point of view of the voluminous record that that court would have to review in order to be in a position to make an intelligent ruling. But it is also perhaps one of the top three most difficult decisions to make in this particular case. In this case, there have been several decisions that this court has had to make that have been difficult decisions to make. And this is an extremely difficult one that I was not looking forward to having to make. Having said that, the canons of judicial ethics and the Code of Civil Procedure do not give to trial court judges the benefit of the doubt. And when a concern is raised regarding a court's ability to be fair and impartial, it is not the actual existence of impartiality or partiality that is the issue, it's the appearance. I would love my wife dearly. And I am wounded by criticism of her. As any spouse would be. And I think it is reasonable to assume that could have some impact. As I mentioned, women in male-dominated professions learn to deal with this, and those who are successful, I think we all observe, are tougher than most. But having said that, the appearance of a reasonable concern that this court could impartially rule on these material issues is there. And I feel I have an obligation then to recuse myself from two issues. One, the scope of the impeachment that is available of Mr. Furman through these tapes, because one might suspect that this court would have a motivation to punish Mr. Furman and thereby make wider the scope of impeachment. Someone might reasonably be concerned about that. One might also be concerned that this court, in trying to express its impartiality, would bend over backwards the other way and restrict it. In either event, there would be concern about this court's ability to act impartially in this matter. I therefore recuse myself from the issue of the tapes themselves, and specifically whether or not Captain York is a material and relevant witness for rehabilitation and or impeachment of Detective Furman, as the case may be. This matter is therefore, this particular issue is therefore transferred forthwith to Department 100 for reassignment. I'm going to order counsel there forthwith for the purposes of selecting a court to hear the matter, to schedule the matter, and to set up a briefing schedule. I think I've had my staff running on the Lexis word search, and we come up with an incredible number of transcripts that are going to have to be reviewed by this court, by the receiving court. I suspect I won't get a Christmas card from the judge who gets this case. My guess is this is 7 to 10 days worth of work. What I propose to do is order counsel back for 3 o'clock so we can finish with Ms. Kessler, which I would like to do today. That will proceed with Mr. Regals, if I hear no objection, so the trial at least can progress while those other issues are being resolved.
The people were requesting the 402, we have no idea of what the defense.
Well, let's take that up at 3 o'clock.
All right.
But what I want to make sure that both sides understand, I want both sides to understand that they have a significant burden and obligation to carefully and fully brief these issues for the judge that gets this issue, because this will be coming out of nowhere for this court. And I'll include in the package that I send the court's ruling of January the 20th, where I frame the issues that are relevant to Detective Furman. from this court's point of view. But your briefs in support or in opposition need be detailed with clear references to where you're referring to in the transcript, and the details of your argument briefly, concisely, and to the point.
You know, main part about what the court will say regarding the jury. I'd propose something. I think perhaps we can conclude discussion of this afternoon, but we would not, we would like to hold back Mr. Regal at this point, given where we are at this point. We'd like to finish Kessler, obviously, she's on the stand, hold Regal back, because we got a lot of work to do also. And the other thing is, I would ask the court during the interim, if you will frame something to tell this jury, this is not our issue. This is not anything that the defense has caused, and during our case, I would ask the court to frame something that indicates an issue has come up, whatever you choose to say to them, that so there's no blame that falls on the defense with regard to this. Because I remember at the end of the day yesterday, the court was a little bit irritable. It was catching, apparently, the witness and the court, and for good reason, obviously. But I think that the jury should be told something that so it doesn't reflect against Mr. Simpson. I think the court would agree with that.
I don't think that's inappropriate. We may be looking at if,
Yes.
depending on how you have this schedule and what you confer and decide amongst yourselves, you may be looking at a
Sure.
couple of days of downtime. I realize that.
So that asks the court to do that. And you can think about it till we come back, and we're ready to.
All right.
Your Honor, there's a problem in that our research has uncovered no capacity to sever out issues on recusal and to recuse on an issue-by-issue basis. And we would need to present that issue as well.
Do you object?
I don't know that we have, can we take waive? I don't know that we can waive. I don't know.
Yes, you can wait.
I mean, that's the issue that we've been trying to wrestle with, is that there's no provision in the code for,
Well, counsel, I would refer you to 170.3B1.
B1.
B1.
May we confer for a moment?
Well, that's an issue that you can take up. What I want to do is get you up to 100, get you situated, get you scheduled, then we'll come back at 3 o'clock and finish Kessler. But your people can think about the issue under 170.3B1.
Man, do I understand the prosecutor's there?
Excuse me, Mr. Cochran. We could reserve our position on that until we come back at 3 o'clock then, Your Honor. Thank you.
All right, we'll stand in recess, counsel, or order to appear Department 100 forthwith. With you, bring your crossword puzzles. We may or may not be able to proceed tomorrow morning, but I just want you to know that I know that you're up there waiting for us, and I'm aware that you're back there waiting, and it causes me great anxiety every day because I know you're there and you're waiting for us to do something. And I've alerted the sheriffs that there's a possibility we may not use you tomorrow to make arrangements to take you to Target to go shopping on an extra day or something, but to be available to do that. And I apologize to you profusely. At the end of the trial, as I indicated to you, we'll have some of the news coverage available to you so you can go back and refresh your recollections as to just what it was that occurred back on August the 15th that caused this delay. I apologize for not being able to give you a better explanation, but please trust me that it is something that's important. All right, I'm going to release you then for the evening. Remember all my admonitions to you. Don't discuss the case amongst yourselves. Form any opinions about the case. Don't allow anybody to communicate with you. Don't conduct any deliberations until the matter has been submitted to you. You all have a good evening. Hopefully I'll see you tomorrow morning with witnesses. All right? All right, as far as the jury is concerned, we'll stand in recess and we'll reconvene and